Hi everyone, welcome to another section on your data privacy and the law. So my name is Adi Damola, and like we mentioned earlier, this is a series to be anchored by myself and Eitayo. So we've had some few conversations around the subject data privacy and protection. So we had an introductory class where we did an introduction and gave an insight on what we are to expect during the course of conversations on this series. So we've had conversation on classification of data, where we talked about personal data, we talked about sensitive data, and how organizations are expected to manage each of these data. We've also had session where we talked about key players in data protection, which we talked about data subject, data controllers, data compliance officers, and the likes like that. So today again we'll be looking at the principles of data. So it is no longer in doubt that data is now one of the bloodline of every business or entity or even a country. Like I mentioned in my previous post where I talked about the fact that data is something that is very important in not just a business but a country, and that's why we have organizations like the National Population Commission in Nigeria that takes census, keep record of all Nigerians. So this is to say that data is something that everyone, individual, private entity, government entity, as long as you have information, you deal with information of people, you're able to make use of information that can be used to identify people, you are dealing in the data environment. So today we'll be looking at data protection principles, and we have some established principles, rules of foundations that govern the use of data, the collection process, the collation process too, and also sharing of data. And even when you are done with the reason why you got this data, some may have to delete them, you may have to just trash them and all. So everything that revolves around data protection, from the point of collection till when the data is being utilized, till when the data is being collated and utilized, and even shared if you have to share with third-party agents. So there are principles that govern all of this. So while the law allows an institution to collect people's data, the law also provides for principles, provisions, regulations, rules that guide how this data is being collected or collated or utilized. So we'll be looking at these principles today, and to start with, we'll be looking at the principle of lawfulness, fairness, and transparency. So when we talk about the principle of lawfulness, this is to say that the data you are collecting it for a lawful purpose, and the process is such that it is fair and transparent. So you are not collecting someone's data for an ulterior motive. So for example, an hospital or a health institution, when a patient comes in, or if you have a patient that you've been treating for a long period of time, it is a lawful purpose for you to ask for the health history of the patient. It is a lawful purpose for you to ask for any information that will help you in providing medical services, in administering drugs, or even in providing and offering them medical advice. So these are lawful purpose. So if, because at the cost of relating with these clients or patients, you get information about their health purpose, and now you are now using it as a means to hunt them or to discriminate against them, and no, that is no longer a lawful purpose. So this is why before any data is being collected, or before you collect any data from anyone, you need to be very transparent on the use of data, why you are getting that data. That's why during the course of this conversation we're still going to be talking about the consent principle. Also, how do you get consent from people? How do you get details from people, their data? Do you inform them, or because you have access to it, you just use it for any purpose? So these are conversations that we have on the long run. So still talking about the lawfulness, the fairness and transparency principle. So data is to be processed for lawful purposes, and the process must be fair and transparent. It must not be done in contravention of any law. So if as an individual, as an entity, you do not have the power to, or you've been prohibited by the law to do some certain things, it is going to be a wrong approach, or it is going to be unlawful for you to retrieve people's data without utilizing them for what you are expected to utilize it for. Then another principle that we also need to avert our mind to is the purpose limitation principle. So this principle is to the effect that, just as the name implies, is to the effect that when you get data from people, you should use it for the purpose for which it is being collected. And when I talked about the lawfulness of data collection, I mentioned that you need to collect data for lawful purposes. So if you've disclosed to an individual that you want to use their data for, let's say, for advertisement purposes, and you are not using it for another purpose, that is wrong under the law. And if you are to look at the regulations that talks about data privacy and protection, and there are compliance obligations, there are obligations expected of any entity that is collecting or utilizing people's data. So you can be found wanting of this regulation. So any data you are collecting, ensure that you use it for the particular purpose in which you are for the particular purpose of collection of that data. And during the course of our conversation on this series, we're also still going to be talking about the rights of a data subject. And data subject, we've explained it in a previous video, so you can check the video out. So still talking about the purpose principle. So you need to get and use this data for a particular purpose. And if there are cases where you are going to be using it for multiple purposes and you have that knowledge, it is expected that you notify the data subject either at the point of collection, or if the need, the purpose was not such that was envisaged at the time of collection, but now that you know that you are going to be using this data for another purpose, it is expected that you notify them so that you will not be in breach of this expectation of the law that data should be used for a particular purpose. And you have to explicitly state the purpose, and not just try to pancake it or cover it, mix it up, such that the person does not really understand why you are using that data. You have to be very clear. There has to be openness. You have to be open to the person and not conceal facts, so that the person will have accurate knowledge and understanding of why we are using his or her data. So the other thing that we'll also look at is the storage limitation principle. So this principle, just like if you observe, you notice that these principles are like they are interwoven. So the storage limitation principle is to the effect that if you've collected data lawfully, you've collected it for a particular purpose, then the length of time for you to retain that data has to be limited. So if I have data for example, I'm a lawyer. If I obtain data from a client for the purpose of providing legal service, like court representation, during the course of making appearances in courts, you all agree with me that the clients will at one time or the other have to give me information about the case, which may demand them giving me some data, so that I'll be able to present their case well and give the court enough information to get the desired result from the court. So if at the time I am done with the case, it is expected that I hand over the client's file back to him. Or if there is a need for me to retain it, there should be a limitation time and this has to be communicated to the client, especially where the client is not pleased with the judgment of the court and there's a need to appeal to an higher court. Then there's a limit to how long I should keep this data, and if I have to keep it for a longer period of time, it is expected that I notify the client to update him or her of how long I'm going to be retaining this data. So this is to say that the law provides that data, you should not just keep people's data endlessly. Don't just think that once you have a data, like the joke that once a soldier always a soldier. So it's not the same with data collection. Once you collect people's data, you should use it for the purpose for which it was collected, and by the time you are done with that purpose, it is expected that you discard it. And we're also going to talk about the process of deleting people's data. So how is it expected that you delete people's data off your record, and while doing this you have to do it in such a way that you ensure that there is not going to be any data breach or in any form whatsoever. So another thing that we also have to look at is the integrity and confidentiality principle. And just as the name implies, this principle is, I would say, is one of the very germane principle, one of the core of data protection. So if you are talking about data protection, there should be a level of confidentiality imposed on you by the data subject, the owner of the data. So you should be able to you should be able to manage people's data to the extent that they have the trust. There's an integrity reposed on you to the effect that you don't disclose this information to third parties. People are able to trust you with their data without it being in the news the following day, or without it being in the general public to the knowledge of those that are not expected to have access to this data. So you need to put measures in place to protect it against any data breach or against unlawful processing. So when people give you their data, what measures do you have in place to ensure that even while you are trying to use this data for the purpose which you've collected it, which we talked about, purpose limitation, we've talked about storage limitation, we've talked about lawfulness and transparency and fairness of data collection process. So you need to put measures in place to ensure that the confidence reposed on you by the data subject is maintained all through the process of the process of processing the data, from how you collected the data, how you collect it, how you utilize it, if you have to give it to third parties, how you manage the data even to third parties, because you can't excuse yourself from any liability if there is a data breach during the process of transferring data within your organization to another organization, especially where the process of using this data requires third parties to analyze this data for you. We've seen cases where people engage the services of third parties to analyze or make use of data that they've been able to collect from people, and this is how they go about their daily operations. They are not giving out those data because they want to, but for them to effectively service a customer or a client, it is expected that they share this data with third parties. So in the process of sharing it with third parties, how do you manage it such that people's data are still well protected and there's no data breach? So another principle of data privacy and protection is the principle of accountability. It's still a fallout of all the principles I've been talking about earlier in this series. So as an institution, an organization, a government body, or even a private individual, it is expected that you can account for every data you receive. You should be able to demonstrate compliance obligations, because there are so many things that are expected of you as a data controller. That is, people that utilize or make use of data received from data subjects. So you should be able to give an account of how you use this data. When you give it to third parties, you should be able to to identify third parties that this data is being handed over to. So when there is now a case of, oh, this data was seen to be used by so person, you should be able to trace it to say that no, this is how we utilize this data, this is the process involved, and no, so that when people ask questions, because they have a right to ask questions, data subject, they have a right to ask you how their data is being processed, how it's being collated, who it is being shared with, and for what purpose it is being used for. So you should be able to account for usage of people's data. So another thing is data minimization. That's another principle, and the essence of this principle is to say that you should not collect more than it is necessary. Like I used the example of an health institution. If you are treating a particular patient, ensure that you get adequate data from the client or the patient, but in the process of this also ensure that you are not taking extraneous data that are not necessary for what you want to do. So you need to ensure that you do not collect more than necessary data, and this will also help you to streamline your obligation, because there's already a purpose for collecting that data. So if you are now asking for other things that are not necessary, or if you are not getting other things that are not necessary, there's a good chance of data breach, because you'll be taking more than you need at a time. So always ensure that when collecting data from data subjects, you do not collect more than what is needed or expected. Collect what is needed for the particular purpose why you are getting this data for them. And lastly, the principle of accuracy. This principle is to the effect that data controllers are to obtain correct data from people. So when you get data from people and there is a change, for example, you get a data that talks about a particular health status of a patient. We've been using the health institution, and you retrieve data from a particular patient, person did some tests and all, and now there is a change in status, either for good or for bad. It is expected that you record this data accurately, because if anyone is going to be working based on that data, they will be able to relate with the person based on the current status of the person. So this is why you need to always update your data collection. Always try to reach out to your data subjects to know if there is any change in their data, in the data that has been given to you. For example, if you are an insurance, if you provide insurance services, either health insurance or vehicle insurance or any kind of insurance, if there is a change in the status of what is being insured, it is expected that you reach out to, you have a guideline, or you have a process in place that reaches out to your clients, your customers, to always give you an up-to-date information, so that you'll be able to service them appropriately, you'll be able to service them as they want to be serviced, and also it will also help you to be able to also protect yourself, and not just even this data subject benefiting from it, but as an entity you'll be able to also protect yourself, so that if there is a need for you to review your terms of engagement with the person or the data subject, you'll be able to do the needful within time. So where the above principles are found wanting in your operations, it can be said that you are in data breach, or you are not compliant with the provisions of the law. So in summary, we always we enjoy you that anytime you are getting data from people, you put all of these principles that we've discussed this day, you put it into practice from the point of collection to the point of utilization, even to the point of either retaining it or discarding the data. So I believe that you've gained one or two insights from today's conversation. You can drop a comment in the chat box of any device you are using to stream this section, and we look forward to hearing from you, and to also answer any query that you might have, or even if you have contributions to make on this conversation. So this is your data privacy and protection. Thank you for joining.